Why can't you sort out an overdrawn director's loan account pre-liquidation? In other words, why can't you do a deal, come to an arrangement on the amount that you will be required to repay to the liquidator before you go into liquidation, and have peace of mind and for everything to be sorted out? And the reason is this, is that it is a complete and utter fallacy that you can do anything other, and it shouldn't happen, but you can do anything other than come to an informal arrangement pre-liquidation. The reason is, and I stress it shouldn't happen even if it can be done in theory, okay, which you can't really, is you are coming to an agreement with somebody who has not yet been appointed as the liquidator. So it's simply not binding. You don't know who the liquidator is necessarily going to be. Unless you are the largest creditor, you cannot determine who the liquidator is going to be necessarily before the company goes into liquidation. And one of the reasons that you're not going to be the biggest creditor is because you've got an overdrawn direct loan account, which means that you're not even a creditor. Now, you may have a situation where there are creditors who are sympathetic to your position. You may even have a connected company as a creditor, and you may, in that respect, be able to control the appointment of the liquidator. However, there's still a further problem, even if that is the case. The liquidator who's appointed cannot come to an agreement with you in respect of the overdrawn direct loan account pre-liquidation. And the reason is it's not permissible. Their conduct before the company goes into liquidation is not to do deals with directors about what happens after the company goes into liquidation. The liquidator comes into office. The liquidator then has to review what went on before the company went into liquidation. So the liquidator, if they were to do a pre-liquidation non-binding agreement or whatever you want to call it, they would be in a position of acute conflict of interest, because they would be reviewing their own advice. They would be reviewing their own work. Liquidators got to be independent in the case of an insolvent liquidation. A liquidator cannot review their own work in relation to post-liquidation obligations. There are obviously things that a liquidator is going to do before the company goes into liquidation, such as assisting the director with the statement of affairs, with the report to creditors, with the company's constitutional setup to get the company into liquidation. But that's simply a procedural issue. That is not taking decisions as to what happens once the company goes into liquidation, which is a completely different ball game. So the liquidator simply, because of a conflict of interest, can't even do it anyway. Ultimately, a director who wants to sort out their overdrawn director's loan account has to wait until the company goes into liquidation, and at that point you can sort those matters out. For more no-nonsense, straight-talking insolvency insights, give us a follow. Questions, queries, concerns, give us a shout. Winner Insolvency, inside out.